I think that makes it 1:30 on the dot. Thank you very much, everybody, for joining us. I'm Abigail Telford, and you can also probably see on your screen Sophie Watson. We are going to talk to you this afternoon about unlawful killing and neglect, and in particular, kind of where you go if you don't necessarily get your unlawful killing conclusion. Part of the reason we created this talk is that unlawful killing is a bit of a non-specific title. It's kind of a bit of a catch-all in terms of a conclusion. And so the plan this afternoon is to dig into what can amount to unlawful killing and some tips and kind of hints to kind of hopefully make that a little bit easier. We will come to the issue in terms of threshold in due course, but that will very neatly carry us over to Sophie, who will go on and talk about neglect, which is the conclusion that we perhaps come across the most frequently when we're dealing with matters that we're not entirely certain quite where they fall in terms of the unlawful killing or neglect threshold. And we will, of course, talk about whether or not neglect is in fact a conclusion. And I'm sure Sophie will be touching upon that. Just so that you're aware of where we're going in terms of unlawful killing, and there's going to be a little bit of a whistle stop of some of the elements of the offences that make up unlawful killing. The reason being is that many of us are far removed from law school, and so when we have been practicing in personal injury, clinical negligence, those sorts of areas for a number of years, it's quite easy to forget what the elements of the various crimes are, but they are in fact very important when you're planning for your inquest. What we're going to start with then is essentially relevant conclusions, and the key here is to go back to the Chief Coroner's Guidance for Coroners on the Bench, which was the 2025 guidance that we've had this year. And that gives you quite a lot of very helpful guidance in terms of unlawful killing. In particular, it talks about what happened and why the conclusion of unlawful killing was introduced. And the primary reason it was introduced was essentially to focus people's minds on the need for a judgment-neutral finding about the deceased rather than about any perpetrator of the act that led to the deceased death. And that really fits with how we approach the inquest, which is very much focused on the individual who died, rather than kind of looking at some of the more extraneous matters. What you can see from this slide is that when we're dealing with unlawful killing, you're dealing with death due to murder, manslaughter, unlawful act manslaughter, gross negligence manslaughter, corporate manslaughter. Those are all quite kind of well known, and infanticide. To flag up what's not included is death by dangerous or careless driving, or offences under the Health and Safety Act which have led to death. What I will say, however, and I caveat that by pointing out that if a driving offence satisfies the criteria for murder, manslaughter, you can still have a conclusion of unlawful killing. For example, if a vehicle is used as a weapon of assault. Now, you necessarily still need to go through the motions in terms of the rest of the elements of the offence, but it isn't necessarily as clear-cut as if it involves a vehicle, then you're not going to get an unlawful killing conclusion. And in fact, a number of years ago, I was involved in an inquest where a vehicle was in fact used as a weapon, and in that case, the crime was a murder offence, and the unlawful killing conclusion was found. And so the headline that you sometimes read in some of the guidance or some of the things that you might read online necessarily needs a slight amount of nuance when you're considering where it takes you. Just in terms of the legalities then, in terms of what you do when you come to your elements of the offence. We will be talking about the elements shortly, but when you're looking at the inquest and the conclusion, what the coroner is looking at is, can each element of the relevant offence be established to the civil standard? Now, we know that we're dealing with the civil standard following Morn, and so that has kind of clarified matters, and we're kind of in a much better position as to where we were previously in understanding that. But there are a few other bits and pieces that it's worth bearing in mind when you're dealing with unlawful killing. One of them is that you can't name the person responsible on the record of the inquest. And so you can see that the Coroners and Justice Act 2009 specifically makes that very clear. So you're never going to be able to get a coroner to say, well, this person has committed this particular offence, albeit everybody who's attended the inquest might well understand what has happened. And that was a matter that was particularly touched upon in the case earlier this year. That's the Glaister and Carr case, in which there was a finding on lawful killing, but the court specifically said that the court was not making a determination of any criminal liability on the part of anybody named or otherwise. And so everybody who was present there knew who was being talked about and what was happening, but there was just this clarification that nobody was going to be named, and essentially that's not the purpose of this process. This is the first part of the particular back to law school matter, which is the Galbraith Plus test. And I flag up what the Galbraith Plus test is because it's really important. Essentially, the Galbraith Plus means that before you get to the conclusions that are to be left to a jury, or in fact for the coroner themselves to consider, the coroner has to consider whether a jury properly directed could find all the elements of the offence and made out on the balance of probability, and the conclusion could be safely reached. So that's your element of your Galbraith Plus test. Bear in mind, if an interested person raises the question of a conclusion and whether or not the Galbraith Plus test is met, and the coroner concludes that it can't be left to a jury, the coroner has got to give a reasoned decision as to why they have reached that conclusion. The reference of that is in Law Sheet 1, and I think it's just a useful one to bear in mind, particularly if you're dealing with a situation where you are asking a coroner to leave an unlawful killing open to a jury. The coroner says no, and a family is concerned about, well, understanding why, for example. And so that can give you a little bit more information and explain what's been going on. There are a couple of other bits and pieces in terms of legalities that it's useful to know. One of those is that where you have got an unlawful killing potential conclusion, but it could also equally come to a point where it is a misadventure or accident conclusion, then the jury should be determined, asked to consider unlawful killing first. So the higher of the threshold, the elements of the conclusion that require the greatest consideration, the most elements of the offence, before, if they then conclude that unlawful killing isn't relevant, going on to consider accident and misadventure. And so that's something to bear in mind. And then the final thing, just in terms of these legalities, is that if the coroner or jury is not satisfied on balance of probabilities that it was an accident or misadventure, then the only conclusion available is an open verdict, an open conclusion. So you can see you have a hierarchy of those conclusions, starting with unlawful killing at the top, and you then work your way down through the hierarchy depending upon the evidence that the court has heard and where they can get to and what they're satisfied in respect of. Right, back to law school. And I genuinely know that lots of people will be aware of the elements in terms of murder. Some of the elements in terms of some of the later manslaughter-related offences, I think, are slightly more nuanced, but we'll touch on all of them because I think it's key to remember them for your preparation for your inquest. So, as I say, flashbacks to law school, the actus reus, which means a human born alive dies as a result of a person's unlawful acts or omissions. The mens rea is, of course, the intention to kill or an intention to cause really serious harm. And that's the bit that you are going to really want to be kind of delving into when you're dealing with the witness or witnesses at an inquest, in terms of trying to establish that mens rea, because absent the ability to establish the intention, there won't be an unlawful killing conclusion based on murder, because you just simply won't have met the threshold for dealing with that. Now, a couple of things to bear in mind. If you're dealing with complex issues to do with intention, remember that the foreseeability of death or serious injury is different to intention. So just because something is foreseeable doesn't necessarily mean that it is definitively intended, albeit a jury can infer intention from the likelihood of that event taking place. And the other thing to bear in mind, again, I think most people will remember this, but we flag it up, is that there is no necessity that the perpetrator should have aimed the act at a particular person. It is merely the intention to kill or cause serious injury in the abstract, which will suffice to satisfy the requirement of the mens rea in the unlawful killing conclusion of murder. We then move on, and this is where it perhaps starts to get a little bit kind of more complicated when we deal with some of the elements of manslaughter, because what you will see here is that there's more than one type of manslaughter. We start with voluntary manslaughter, and so your starting premise with manslaughter is you have the same actus reus, the same act as murder. The person has died as a result of somebody's unlawful acts or omissions. In terms of voluntary manslaughter, it's the same mens rea, so the intention is there, plus, on top of that, either the loss of control, diminished responsibility, or suicide pact. Those matters will all necessitate questions being asked in terms of properly understanding whether there were genuinely issues to do with diminished responsibility, whether there was in fact a loss of control, all those sorts of bits and pieces that you really factually need to delve into. Involuntary manslaughter is where you have the intention is sufficient if the person committing the harm deliberately intended any unlawful act of violence with the result that the victim died. And so what you'll see is that gross negligent manslaughter forms part of involuntary manslaughter. Bear in mind there are, again, a couple of bits and pieces to do with this. One of them is in terms of unlawful act manslaughter. Unlawful act manslaughter is where you have an unlawful act. It's dangerous, which is judged objectively, that act, and that results in death. And so in those circumstances, you can reach the conclusion of an unlawful killing conclusion by establishing the unlawful act and that it was dangerous and that it resulted in death. So that is one way through. A couple of other bits and pieces to be aware of. It is that where a person deliberately kills another and they were insane at the time that they did that, they killed that person, the appropriate conclusion in a coroner's court is not unlawful killing, but an accident or misadventure, or in fact an open conclusion. And so there are a few nuances here that it's worth bearing in mind. The final thing just to flag up in terms of involuntary manslaughter is that, in the same way as applies with all of the law that we deal with, is that there is no intention. So there is no requirement on the part of the person who's committed the act that they know that the act that they've committed is unlawful. It is merely enough that it was in fact unlawful. And so that again will get you over the threshold in terms of that. Gross negligence manslaughter. Gross negligence manslaughter is the element of unlawful killing that I think I come across most frequently. It usually arises where the acts that have been carried out by individuals are so bad that in particular a family will be pressing to say there absolutely has to be a conclusion of gross negligence manslaughter. The thing to bear in mind is that the threshold is high, and the threshold means that you have to jump through a number of hoops in order to get to a conclusion that is based on gross negligence manslaughter. The elements were set out in the case of Crown and Broughton in 2020. And what they said is that you have to establish that there was a duty of care, which is usually not going to be overly problematic. I think most of those who will be joining this call today will be very familiar with the need to establish a duty of care, and very commonly it's not going to be significantly in dispute. The occasions where it might be slightly more problematic are when you're dealing with individuals who are perhaps slightly removed from the person who has died. So sometimes when the person has died and there's been arguments in terms of probation services and whether probation services owe duties to those who, for example, weren't necessarily being monitored. And so things become slightly more complicated, and there's greater argument in those sorts of circumstances. Along with your duty of care, you need to establish that there is a breach of that duty of care. And so that would be done in the usual way, the kind of the going through what the ordinary threshold would be and the care that would be expected, and that care that was provided fell below the standard that one would expect. Moving through, you then move on to the serious, that there was a serious and obvious risk of death at the time of the breach of duty. And you can see that moves through then, that it was reasonably foreseeable at the time of the breach that the breach gave rise to a serious and obvious risk of death. And so we are judging this on the basis of at the point at which the breach of duty took place. So we can't apply the benefit of hindsight, which I know is very difficult sometimes to disentangle, but we are looking at this as from the perspective of what was known at the time. And that when we look at it, it has to be obvious. There has to be a clear, serious and obvious risk of death. And if it's not serious or it's not obvious, then you are not going to meet this high threshold that is set out in Broughton. The causation is a matter that is obviously very difficult and sometimes proves a sticky point in inquests in terms of how far we go as to trying to work out what exactly caused the death. But if you were looking for a conclusion of gross negligence manslaughter, it is really very important that you are not going to have an argument that this person would have died at the same time anyway, because if there is that legitimate argument, and I would expect clinicians that would want to address that and the coroner would want to explore that, then you're not going to be able to establish causation, that namely the acts have led and caused the death. And finally, this is an issue that is particularly difficult, which is the conduct has to be so grossly negligent as to justify the conclusion of gross negligence, which is a little bit of tautology there in terms of defining gross negligence by reference to grossly negligent. But what it essentially means is that the coroner gets quite a lot of discretion here. The coroner is going to need to hear that the threshold for the level of care that's been provided has really gone over the threshold of anything that could reasonably be expected. And as a consequence, it is going to have to be really pretty bad to be able to meet that threshold. I think it's more likely that those sorts of conclusions are going to be found when you have got individuals who are vulnerable. So children, people who don't have capacity, the elderly perhaps, who are very reliant upon others for their care. It's going to be much easier to establish that there has been gross negligence where an individual is so wholly reliant for their care upon somebody else, or for example, where they're not capable of assessing risk, those sorts of matters, because it will have to be really very bad to meet that threshold. And so that's just something to bear in mind. The bits and pieces to bear in mind here is that evidence of state of mind is not required. And so we're not looking here at what was intended. Foreseeability is based on an objective test. And so you're not going back and trying to piece things together after the event with a witness, which can often be very difficult. I find Broughton very helpful. I would really recommend going and looking at Broughton if you are going to be looking at a case through the perspective of whether or not you can make reasonable submissions to a coroner about gross negligence manslaughter, whether you're doing so on behalf of a family who want such a conclusion, or whether you're doing so on behalf of another interested party who thinks that the threshold isn't met. But Broughton, I think, is very helpful in that sense. If you were looking for a little bit more reading, you can also go back to Adamoko, which is 1995, which was kind of the precursor to Broughton, albeit Broughton I found is kind of a nice update in terms of that. Right, moving on. These are the parts of the offence, the offences that I thought perhaps people might not be as familiar with. Mainly because, at least for me, I always, of course, had kind of that harking back to law school in terms of some of the more primary offences in terms of murder, manslaughter, those sorts of things. But corporate manslaughter is something we touched upon a little bit less. I would really implore any person who was thinking about whether or not there can be a corporate manslaughter conclusion to go and look at the Corporate Manslaughter and Corporate Homicide Act 2007. There are a lot of sections in terms of this act that are relevant, and that there's quite a lot to it. Being short about it, we could have an entire talk that kind of goes through all of the elements and how they work, but I think for the purposes of today, it's kind of a useful summary for you, which is that section 1.1 makes clear that an organisation to which this section applies is guilty of an offence if the way in which its activities are managed or organised causes a person's death and amounts to gross breach of a relevant duty of care owed by the organisation to the deceased. So here that duty of care is under negligence or a statutory provision imposing liability. So I think most people will be familiar with what that means, and I don't think that would cause too many difficulties. Relevant points here are that this now means that those who are caught by the Corporate Manslaughter Act are not now liable to gross negligence manslaughter at common law. And so it's a shifting of some of the corporate side of things out of gross negligence manslaughter and under this act instead. It applies to certain organisations, not all organisations, which is why I'd really implore you to look at the act. The organisations include corporations, police forces, partnerships, trade unions, employers associations, and helpfully other departments or bodies specifically listed, which is why I suggest that you kind of go and look at the act. The definition is subject to certain exceptions, and so bear in mind that there are certain things that won't apply. For example, the activities of the military, emergency services, others, which is always kind of your small print text that you want to be double checking. The breach here has to be a gross breach, and what they mean by gross is it has to fall far below what can be reasonably expected of the organisation in the circumstances. And so we're not dealing with kind of a minor breach or something relatively small, which has led to unintended, particularly awful consequences. You're looking at the act itself, and it has to be a particularly bad, awful, gross act to meet that threshold. And so I think that's something that's important to bear in mind. Again, with these sorts of things, if it is kind of proving a little difficult, there are books and resources available. One of the great ones for those is Jarvis on coroners. And Jarvis essentially says that when a jury is considering whether an organisation committed a gross breach of the duty of care, they must consider whether the evidence shows that it failed to comply with the relevant health and safety legislation, and if so, how serious it was and how much of a risk of death it posed. It may consider how far attitudes, policies, systems or accepted practices within the organisation were likely to have encouraged or produced tolerance of the failure, and they may also have regard to any relevant health and safety guidance or other matters they think are relevant. And so for this, a jury is going to have a fairly wide view as to what may or may not be relevant, and so you might well find that there's quite a bit of evidence dealing with this. I would anticipate that if you're dealing with corporate manslaughter, you're going to need written submissions. The act is not straightforward. And so I'd really suggest that it is something worth kind of thinking about early on, because when it comes to assisting the coroner with corporate manslaughter, I think the nuance and the detail is really going to be the key here. You're not going to be able to kind of address kind of the facts at length, but you are going to be able to address the law in terms of clarifying that, which is really going to help you one way or the other, whether you are trying to dissuade a coroner that this is an appropriate conclusion or persuade a coroner that it is in fact relevant. Infanticide was, and I think Sophie probably remembers me discussing this previously, but infanticide was something that I'll be honest, I hadn't considered for a very, very long time when I started preparing this act. But when I went back to it, essentially infanticide means that a woman by willful act or omission causes the death of a child under 12 months of age. At the time of the act or omission, their mind was disturbed by the effect of birth or lactation. But for this act, the offence would otherwise amount to murder or manslaughter. And so what it just means is that if you're dealing with a case where a woman has killed essentially their child, their baby, and they're under 12 months of age, you are not necessarily automatically going to be looking at manslaughter. You might want to be looking at infanticide first and just seeing whether you meet the relevant criteria for that, and your starting point there is going to be section 1 of the Infanticide Act, but realistically some of the older acts are slightly more archaic, and I do suggest that going back and looking again at some of the guidance. So the Chief Coroner's guidance is always helpful, of course, and the bench book, along with the guidance that you'd find in Jarvis and other such texts. I will move us along to our next slide, which deals with defence, really. So the first and the most significant defence that I was going to talk to you about was that of insanity, because your defences are relevant when you are dealing with potential unlawful killing conclusions, because in the same way as applies in the criminal courts, within the civil courts, if there is a relevant offence, but there is also a defence, then that of course adjusts and modifies what the finding may or may not be. Here, I touch upon insanity because I think insanity has always been slightly nuanced in terms of the wording, and we need to be kind of careful to make sure that we remember what that is. Insanity is defined by reference to Macnaughton's case in 1843, archaic cases, as I referred to. But this one means that somebody was labouring under such a defect of reason from mind or the mind so as to not know the nature and quality of the act he was doing, or if he did know it, that he did not know what he was doing was wrong. And when they make reference to wrong, wrong is not morally wrong, it is legally wrong, namely kind of unlawful. And so it's that understanding that's kind of the really key thing there. So if you're dealing with these matters, there's going to need to be a really kind of detailed exploration of some of the psychiatric, psychological side of things in terms of trying to establish whether or not there is this defect of the mind that it would be present. Bear in mind that if it's raised, it has to be disproved on the balance of probabilities before an unlawful killing can be reached. And so that's really, of course, going to be important, because once it's raised, you have to deal with it. There's no dodging it. And that where a defence of insanity does apply, the only appropriate conclusion is then accident, misadventure, or an open conclusion, as is necessary in any particular case. This is going to lead to, I think, a significant increase in the amount of disclosure you're likely to receive, which means you really want to get ahead of it early, which we'll come to shortly. I've added in an additional slide because Sophie and I briefly talked about this some time ago. But we've, after I gave the talk last time, a coroner, in fact, came to me and he said, I appreciate that your talk is about unlawful killing, but please could you include a slide saying that there can also be a conclusion of lawful killing? And I said, fine, not a problem. So here we are. And essentially that what that was to do with is the fact that you can have all of the elements for an unlawful killing that might be there, but there is a way, as a consequence of, for example, self-defense, that you can get to a point where a conclusion might be one of lawful killing. And so that is something to bear in mind. Consider that the death is as of an action justified in law. It is still a deliberate act, and for example, self-defense is a key there. There has been some criticism about whether lawful killing is helpful as a conclusion because it might be confusing or misleading. It kind of potentially expresses some degree of judgment, which of course certain parties particularly don't like. But I flag it up because it is there, and as I said, a particular coroner mentioned it to me. If you have got concerns about whether or not there might be a relevant self-defense argument, I'd really suggest going back to Duggan, which is the 2017 case. I think many people will remember Mark Duggan and the case relating to him and his inquest. And it is a criminal defence, of course, so you're dealing with the relevant elements, but Duggan's quite helpful because it deals with directions that you can give to the jury in terms of dealing with this, but it also sets out kind of what the relevant law is. And the relevant law is any person is entitled to use reasonable force to defend himself or another from injury, attack, or threat of attack. Did the individual who committed the fatal act honestly believe, or may he honestly have believed, even if his belief was mistaken, that at the time he fired the relevant fatal shot, he needed to use force to defend himself or another? If the answer is yes, was the force used reasonable in the circumstances? And if the answer to that was yes, then the defence of self-defence was applicable. And so that is, I think, a really helpful case if you are kind of struggling with some of the elements of that. Right. The excuse me. Yes. So the next slide I was going to deal with is just some of the practicalities, because I think it's probably helpful when we've gone through all of the elements of the offence to bear in mind some of the things we need to be kind of alert to. First one, it might seem obvious, these sorts of things sometimes slip your mind when you're in the middle of a stressful case and you've got a busy caseload. Bear in mind what the age of criminal responsibility is. If the individuals who have committed the acts are below the age of criminal responsibility, then of course there's going to be difficulties in terms of reaching conclusions of unlawful killing. Remember that this is an inquisitorial process, not an adversarial process. We are there to assist the coroner, irrespective of which interested person we represent. And so we in our role as lawyers are there to clarify and help clarify whether or not the thresholds have been met, and whether or not the relevant elements of the offence are there. And actually, I think that is the most difficult thing, is making sure that the evidence has properly been drawn out so that those elements of each of the offences can be addressed and talked about in terms of whether or not they have been met for the appropriate conclusion to be reached. My view, and I have quite a strong view about this, is that if you are thinking about a conclusion of unlawful killing, you have to think about it well in advance of the inquest. Ideally, you're thinking about it before your first pre-inquest review hearing, because what you're wanting to do is you're going to want to make sure that the relevant witnesses are called, that the relevant disclosure is there to deal with all of these issues. And it is much harder to do that once you are at the actual inquest and draw that evidence out of your witnesses, if two things have happened. One, if you don't have the right documents and witnesses, fine. I think that's obvious, it's going to be a problem. But two, and it leads on to the third bullet point that I have, is if the coroner isn't alert to the fact that this is a concern or an issue that you have, a coroner is going to potentially say, hold on a minute, I didn't think that we were anywhere near the threshold for gross negligence manslaughter. And so why are you trying to draw the evidence out like this? Because I just don't think we're there. Whereas if it comes as no surprise and you've dealt with indicating your concerns to the coroner clearly and early, I think it is much more likely that you are going to be able to kind of go through the evidence in a way that might well be a bit of a tick box exercise in terms of working out whether or not each of the elements of those offences is met. I very strongly think that kind of exploring the issues in a way to assist the coroner is kind of the key here in terms of trying to map out where you are. And I think being quite open about that if you are at an inquest and dealing with witnesses is really quite important. But the key thing really, to my mind, is practically, are you going to meet a high threshold? And remember, the conclusion is only going to be one of unlawful killing. It might be as a consequence of having met the relevant elements of an offence. But if it's only going to be the conclusion of unlawful killing, do bear that in mind, because I think sometimes you might find that families are a little bit perturbed, for example, when they thought that they were going to get gross negligence manslaughter as a conclusion, but in fact the conclusion is unlawful killing. If you are not going to meet this high threshold in terms of gross negligence manslaughter, for example, bear in mind that there is the issue of neglect. And I think that's probably quite a neat move, Sophie, for us to move over to you to deal with the issue of neglect and how that should really be dealt with at an inquest.
Thank you, Abby. As Abby said, that neglect is something you might want to consider alternatively to gross negligence manslaughter. It's not quite the same high threshold. Indeed, as Abby's talked about, that is a very high threshold, but neglect is still has a fairly high threshold and it's quite prescriptive. So hopefully today I can just recap some of those elements for you and just highlight again some practical points. Neglect in of itself isn't a conclusion, but it is something that can be added as a rider to a short form conclusion. So you might be looking at natural causes contributed to by neglect, or it may be something part of a narrative conclusion. And I've just popped in there at the top the Chief Coroner's Guidance for coroners on the bench, it should say, rather. I've put guidance in there twice. But the chapters there, it's chapter 15, and when we're looking at conclusions, paragraphs 80 onward, that's a really useful starting point. It sets out all the relevant case law and aspects that you may need to look at. So that's a great starting reference. I've put there at the top, it is quite restricted in its meaning, so we will shortly be going through the elements of that. But it's useful at that point to just really highlight that it does not equate to negligence in a civil law claim. So that's something that I think, especially if you're acting on behalf of the family, you may want to get that point across to them at the outset, because crucially, the test isn't the same, particularly with that of the causation aspect. I've had cases where the coroner has found neglect, and unfortunately, it's not borne out in a claim thereafter when we've reverted to an expert, because we don't have, particularly as I said, on the causation front, that we know that test is distinctly different, and it doesn't translate into the civil standard. So again, I recommend laying that out at the start to any party you represent, really, but crucially, if it's the family who are sort of assuming that might mean they're going to go on to have a successful civil claim thereafter. The leading test, it hasn't changed in recent times, fortunately, and that is the case of Jameson. And again, that is one of the leading cases where it's set out that this is rarely a conclusion in of its own. So as I've said earlier, it's something that is either a rider or part of a narrative. So on the next slide, if we come to that, you can see there that the test is set out, paragraph 9 in Jameson, and its neglect in this context means a gross failure to provide adequate nourishment or liquid, or provide or procure basic medical attention or shelter or warmth for someone in a dependent position because of youth, age, illness, or incarceration, who cannot provide for himself. Failure to provide such medical attention for a dependent person whose physical condition is such as to show that he obviously needs it may amount to neglect. Now, I've set that out there. In the paragraph thereafter, that's the paragraph 10, that goes on to talk about it not being a conclusion in isolation. Well, let's break that down in the next slide to the particular elements of it, because of course that's quite a lot of information of itself to take in. So if we break that down into the individual components, so we've got a deceased in a dependent position, and you'll have heard me in that particular passage referring to youth, age, and illness. And that's crucial because a dependent position, we're looking at in this case at somebody who might be under hospital care, incarcerated in prison, in a care home, anywhere where there's somebody who's vulnerable and dependent on the care afforded to them. So that's the first point. The second is this idea of a gross failure to provide adequate nourishment, liquid, or procure basic medical attention or shelter or warmth. So really what you're looking at here is gross failure to provide a basic need, or if you're looking in a hospital setting, medical attention. And you may have heard emphasis there from me in respect of the provide or procure. And I think it's useful to point out that it's not necessarily just providing it directly, but in instances it may be procuring it. So it may be that an ambulance hasn't been called for medical attention. That's procuring medical attention. Or it may be, for instance, a hospital might need to outsource something or call upon a specialist team, and they're procuring that basic medical attention. So it's useful just to highlight that particular point. And then we've got the aspect of causation, which we'll look at shortly, but there's got to be a clear and direct causal link between that gross failure and the deceased's death. So just moving on to slide 4, which we're just going to go into a bit more detail on those elements I've set out. So the dependent position, that's very straightforward. So really I've started here by looking at what is a gross failure. And rather unhelpfully, we've not got guidance on that, but I would look at it in the ordinary sense. It's not something that is gross negligence, but it is something, there's an emphasis on the word gross, that is a significant failure. So just looking at the case of Khan, I'm sure that's one we'll all be aware of, but just to sort of briefly recap on the facts of that to highlight what we're looking at when we're looking at that sufficient level of fault. In this, Mr. Khan, he was detained on suspicion of drug offences, and he had a package of drugs in his mouth, which ultimately burst, and that intoxication from those drugs caused Mr. Khan's death. And the coroner in that particular case didn't leave the potential conclusions of unlawful killing, breach of right to life, and neglect to the jury. In this case, was specifically looking at the timings of an ambulance, and it was held on the evidence that a failure to call an ambulance before the package was known or believed to have burst in Mr. Khan's mouth was not a gross failure to procure medical attention. And indeed, police officers before this had tried to remove it, and Mr. Justice Richard found that it'd be offending common sense, essentially, to call an ambulance before it had burst. But when the powder was present on Mr. Khan's lips, and we're looking at a different situation, an ambulance was called. So it was found in that particular case, there was no basis which a jury could reasonably conclude that there were signs of a leakage prior that should have been spotted in an ambulance called. And I just highlight this case because, as I've said, it's an example where there's lacking support that there was sufficient fault in this particular case by the police. It may have well been a different situation if we're looking at the police knowing that it potentially could have burst and having left that before procuring medical attention for Mr. Khan. So we're looking at that sufficient level of fault. Just in respect of what we can mean by gross failure, this can indeed be a series of failings that cumulatively amount to neglect. Now, I think, I hope this may be the case, but I'm under the understanding many other practitioners saw the case of Maguire, the first appeal to the divisional court, and thought this isn't the case. The coroner in Maguire considered the question of whether neglect ought to be aggregated or left to a jury on a cumulative basis. And the coroner in those circumstances concluded that it'd not be Galbraith safe to leave the neglect to a jury in the circumstances. And he concluded that it wouldn't be appropriate to leave the cumulative failings. Now, when it was the judicial review, counsel for the claimant argued that the coroner was wrong to proceed on the basis that the presence of one or more individual failings couldn't amount to a gross series of failings and therefore justify a conclusion of neglect. And I think that's where the confusion comes from, is counsel's argument. But in fact, when you read paragraph 58 of the judgment, the appeal to the first divisional court, in that it was found essentially that the coroner had considered that. It was just actually on his assessment of what would be safe to be left to the jury on the Galbraith test. He didn't think that all of those cumulative acts could amount to gross failings. So he had indeed considered that, but it was just overall concluded that it was not satisfactory to leave it to the jury. So I've just added some examples to the slide there, which are the prevention of future death reports, the two psychiatric cases, Jamie Harding, for instance, the inquest into his death. There was a number of failings. So, for instance, failing to follow up a care plan, review his medication, to hold a multidisciplinary meeting, and all of those together had amounted to a gross failing. And it was concluded that there was the cumulative effect of those failures amounted to neglect, particularly with respect to the basic medical care. So that's just an example. I've not linked this on the slide, and I perhaps do need to update them before they go out. But Abby had a case earlier this year, Miss Maxine Spittlehouse. In that particular case, there was Miss Spittlehouse had a hysterectomy and suffered internal bleeding. And that case is another good example because there was a number of missed opportunities to identify that bleed. And the coroner in that ultimately found that there was cumulative failings on the part of the junior doctors and consultants to ensure there were basic checks to identify that Miss Spittlehouse was bleeding internally. And those included not obtaining blood results earlier, not escalating concerns to the consultant surgeon, and not transferring her to a hospital where that could be treated. I've referenced on the slide as well basic medical attention, and you'll see there I've quoted the case of Nichols, which is referred to in the bench book as well. And in this, it sets out that in a medical context, it's not the role of an inquest to criticise every twist and turn of a patient's treatment. Neglect isn't concerned with the complex and sophisticated medical procedures, but rather, for example, the failure to make a simple basic check. Now, it's worth pointing out, though, however, a basic check might be slightly different in a medical's context, because that can we can be looking at failure to assess a blood result, or as I've identified in Abby's case, not escalating concerns. But that is different to perhaps that basic check might necessitate some complex medical life-saving treatment, but that's not what we're looking at. We're looking at the failure of the basic check earlier on. So it may be easy to get slightly confused on the causation point. And in Abby's particular case, surgery for rectifying internal bleeding will be quite complex, but that isn't the basic medical attention of or early failure. Actually, the basic medical attention that we're looking at is the failure to escalate it to a consultant. So the much simpler checks that weren't performed that have necessitated in that. Then we're just going to look at the next slide, which relates to causation. And this is a test that we'll all be well versed in. Indeed, it is the test for causation that is dealt with in any aspect of inquests. So there needs to be a direct and clear causal link for cases of neglect. It's not enough to just show there was a missed opportunity which might or may have made a difference. We're looking at that test of it more than minimally, negligibly, or trivially contributed to the death. So you really need to highlight that in the inquest. And whilst, again, the test is different to what we see in a civil setting, it is on the same standard of proof, so on the balance of probabilities. I've mentioned the Galbraith Trust, the Galbraith Plus test rather, which Abby's referred to earlier. Whilst this is on my slide for causation, it is worth pointing out that it needs to be Galbraith Plus for all elements of what you're trying to identify. So neglect, the element that there's a gross failure, still needs to be, if it's to be left to a jury or something the coroner considers, it still needs to meet that Galbraith Plus test. But I find that a lot of it comes down to this aspect of causation, where that usually comes into play. But indeed, it is just worth mentioning that goes to all elements of what it is you're trying to get forward as a conclusion. So I won't go through it because obviously we've heard from Abby on that particular point. And I've not referred to this on this particular slide, but there was recently a case of Crown Drysdale against His Majesty's Area Coroner for Manchester. And that is quite an interesting case, because that one looks at whether it's safe to leave neglect to a jury. And in that particular case, it just highlights this point on causation. Miss Drysdale was prescribed an antipsychotic drug, and that the drug specifically she was prescribed was clozapine, which affects white blood cell counts. And the Miss Drysdale ultimately ended up with acute myeloid leukemia. And the family were concerned as to whether there was a link between the antipsychotic drug she'd been prescribed and whether there should be some sort of earlier detection of perhaps that it wasn't just the medication affecting her white blood cell counts, but potentially an earlier sign of this leukemia, and trying to link that between the drug and ultimately the acute myeloid leukemia, which caused her death. Now, the conclusion in this case was one of natural causes. So looking at judicial review, it was argued, one of the second grounds particularly, whether the coroner had wrongly decided not to leave that conclusion to the jury. And in the inquest, the evidence was really, the link was pretty sparse. I think it was referred to as relying on a speculative data set. The psychiatrist hadn't come across this particular link. The haematology evidence didn't necessarily support the link. There was 1 week study, I think, from 2010, so quite considerable time ago, and there really wasn't much to establish that there was a direct causal link that would surpass the usual test for causation. So ultimately, it was decided in a judicial review that the coroner had been right in not leaving that to the jury, because there wasn't sufficient evidence for it to be safely left. And in line with the Galbraith Plus test, no jury could ever properly reach a conclusion of neglect on the evidence that was before them. So ultimately, there was no that wasn't taken any further. So that's just useful. So this case of Drysdale to look at if you want to look at particularly the causation aspect as to whether it amounts to that hurdle. And lastly, before I come to just some practical points, I've referred to the case of Lewis in 2020. Before Drysdale, this was one of the, I say, most recent cases. It is still a considerable time ago now, but of course the test hasn't really changed massively since Jameson. It's been the same test since then. But this is just a really useful case that gives us a reminder of the test for neglect. So paragraphs 24 to 26, that's where it sets out really that test that we've just been referring to. I've just put in briefly the facts in this case, because differing to the case of Drysdale, in this, the coroner didn't leave neglect to the jury and gave no reasons for doing so, but it was determined actually it did meet the Galbraith Plus test in this particular case. So it's been declined to have made a finding in the particular case, but it's been left to a new jury. So it'll be interesting to see ultimately when that is listed what the outcome for that case is. And finally, just touching upon some practical tips. As I mentioned, it's not quite the same high threshold as gross negligence manslaughter, but it is still quite a high threshold. And as we've been through, there are quite prescriptive points that you have to meet with the basic checks and failings. So it is something that you do need to manage your client's expectations at the outset. And also, again, as we've referred to at the start of my section of the talk, it doesn't equate to that civil negligence claim. So it's useful to manage your client's expectations. Equally, if you are representing another interested persons, you want to give them that reassurance that potentially that isn't something, particularly if you think the evidence isn't there. As Abby referred to with gross negligence manslaughter, it's useful just to have in any inquest you're doing an idea of where you perhaps might want to go with a conclusion, particularly when you're examining a witness. You want to be able to feed those terms into that examination. So exploring whether it is a basic check, what does that mean by basic, whether it can be a gross failure, and dropping those seeds in for the coroner or the jury. So it's useful to know where you're heading with that. And equally, if you are for an interested person who's trying to guard against that particular finding, if you've explored this already with your witnesses, you might have some really strong evidence that actually it doesn't go to, it's not a basic check, or perhaps it's not a gross failure. Then counsel, you can feed that to counsel, and they're able to put that into their examination of their own witnesses, because we're in a unique position in inquests whereby we can not necessarily lead our witnesses on that, but explore that with them in greater detail. And if you know you're going to get some clear answers on that are helpful, that certainly can be explored in the inquest. But I would guard against that if perhaps that's not something your witness is quite clear on, but it's just useful if they are. As we've referred to earlier, basic medical attention may not be as basic as you think. So in a particular case I had at Christmas of last year, there was an outsourced CT scan that had failed to advise a gastric band had slipped, and that contributed to the failure to refer the lady to a bariatric specialist. And it was found that there was neglect in care as part of the narrative conclusion. So, of course, checking and reporting a CT scan to anyone not in a medical arena doesn't seem basic, but it's something that didn't obviously meet that standard for the coroner. So it is worth just looking at it in a different light for when you're looking at basic medical attention, exploring that, especially if you're with the benefit of being representing a trust, for instance, whether that is actually something they consider basic. And finally, this just goes back to the cumulative point that I referred to earlier. Just don't look at those failures in isolation, but we need to be looking at them as a whole. So it may be that as a whole, they do amount to that high threshold. So it's something definitely worth considering. So on the final slide, we've just put our email addresses. I am conscious that it is close to the end of the talk and the lunch period. But if you do have any questions, you're more than welcome to drop either Abby or I an email with those questions.